The Federal Court today has delivered yet another landmark decision. Now, the five-man justices chaired by Tun Arifin Zakaria has said that the Sedition Act 1948 is, after all, constitutional. Now, this will affect some 30 politicians, government critics and student leaders, some of whom have been charged under the Act since last year.
Since the Sedition Act is pre-Merdeka legislation, it has to be distinguished from post-Merdeka legislation. Therefore, Article 4 of the Federal Constitution has to be taken or read in different light. They have the view that because it is pre-Merdeka legislation, Article 160(2) of the Federal Constitution provides that it is still enforceable and therefore it is constitutional. That is the short of it. Insofar as Article 4.1 and Article 10 is concerned, they are of the view that the reasonableness test, in other words, the scope of courts to determine whether or not a judgment or a statute is reasonable, as expounded in Siva Rasa, is no longer applicable. But for now, the court has decided or directed that the prosecution against Professor Azmi proceed in the Sessions Court. So I think we will have to go back to the Sessions Court and go to trial.
I'm surprised that they did not agree with a very strong argument, because at the end of the day, why is it that in the Constitution only Parliament can make laws to restrict freedom of speech? Because Parliament is democratically elected, and that is very, very important. That we have a democratically elected body and only they can restrict our freedom of speech. And I think this is a point which unfortunately was missed. And I'm very upset because I think this is a sad day for civil liberties in Malaysia.
Today is a dark day for human rights, because always we study in constitutional law. There's a case, Siva Rasa, which says that all restrictions towards Article 10, freedom of speech, must be reasonable restriction. That is the precedent. But today that case was overruled. So now the law says that Parliament can make any restriction to Article 10 deemed necessary or expedient. Means the court now plays a role as rubber stamp. What the Parliament decides, court just follow, chop, that's it. Alright, the court cannot interfere and says no, what Parliament did is wrong, alright, towards Article 10. So it's a very dark day for human rights, and it is very sad on our part. So